Supreme Court has dismissed the review plea filed by the Maharashtra government on the Maratha Quota. Now, the five-judge Supreme Court bench ruled that there was no exceptional circumstances which require the government to break the 50% ceiling limit to bestow quota benefits on the Maratha community. And the MVA government had challenged the May 2021 judgment, which declared the law providing reservation to the Maratha community in excess of 50% limit as unconstitutional. Now, the scrapped quota extended 12% and 13% reservation to the Maratha community in education and employment in the excess of the 50% ceiling limit fixed by the top court.
मराठा आरक्षण मराठा रिजर्वेशन के बारे में जस्टिस भोसले कमेटी का जो सुझाव था, रिव्यू पिटीशन में स्कोप कम है ऐसा उनका सुझाव था, फिर भी उसे दाखिल किया था पिछले सरकार ने। उन जो कोर्ट के जजमेंट में जो फाइंडिंग थी, जो ऑब्जर्वेशन थे, उसके लिए जो जस्टिस भोसले कमेटी ने सुझाव दिए थे उस पर हमारी सरकार काम कर रही है। मराठा आरक्षण देने के लिए, मराठा आरक्षण प्राप्त करने के लिए जो भी करने की आवश्यकता है वो हमारी सरकार करेगी।
All right, let's go straight across to my colleague Harish, who is joining us on the phone line for more details on this. Harish, if you could help us understand why the Supreme Court has dismissed the review plea filed by the Maharashtra government on the Maratha Quota.
Yes, a very big development as far as the row of the Maratha quota is concerned, the Maratha reservation is concerned. It's seen as a setback for the Maratha community in Maharashtra. Now, a five-judge bench of the Supreme Court has dismissed a review petition filed by the then Mahavikas Aghadi government on June 23, 2021, challenging the May 5, 2021 judgment in which the Supreme Court had declared a law which provided reservation benefits to the Maratha community, taking the quota limit in the state in excess of 50% as unconstitutional. Remember, the bench led by Justice Ashok Bhushan had found there was no exceptional circumstances or extraordinary situation in Maharashtra which required Maharashtra government to break the 50% ceiling limit to bestow quota benefits on the Maratha community. And this is what the five-judge bench said while dismissing the review petition. It said, having carefully gone through the review petitions, the judgment under challenge and the papers annexed therewith, we are satisfied that there is no error apparent on the face of the record warranting reconsideration of the earlier judgment passed in May 2021. The review petitions are accordingly dismissed. Pending applications stand disposed of. So this is what a five-judge bench said. Remember, the scrap quota had exceeded 12% and 13% reservation, as you rightly said, to the Maratha community in education and employment respectively in excess of the ceiling limit of 50% fixed by the Supreme Court earlier. A 50% cap in reservation was fixed in the Indira Sawhney judgment passed by the nine-judge bench. But now the Supreme Court has on two rounds dismissed, quashed the quota and saying that it found there was no exceptional circumstances or extraordinary situation to breach that 50% ceiling fixed by the Supreme Court in the Indira Sawhney case. Back to you.
Right, Harish, many thanks for joining us with all those details.